Welcome back. This is still The Point of View. We're speaking to Right Honourable former Speaker of Parliament, Professor Rerun Oquaye, looking at a number of issues. We're turning attention to a big issue now. The Tamale High Court annulled the 2024 parliamentary election results and ordered a rerun of the Kpandai election. Now, this is very controversial because, as we speak, there are two cases. There's a High Court matter and also a Supreme Court matter that the MP, or the former MP, if you want to use that expression, has taken up. Already, the Parliament has declared the Kpandai seat vacant, and the EC has proposed a by-election date for 30th December. Now, some quick background to this. The NDC candidate for Kpandai, Daniel Nsala Wakbal, on December 23, filed a petition at the Tamale High Court challenging the EC's declaration of Mr. Nyindam as MP for the constituency. He alleged that the result of the parliamentary elections, as declared by the EC, was invalid due to some irregularities and inconsistencies contained in some of the pink sheets. The former MP argued that the Form A for 41 out of the 152 polling stations contained some inconsistencies and irregularities. He added that the election held on December 7 was inconsistent with Regulation 39 of the Public Elections Regulation, CI 127, as well as the principles laid down by Regulations 39 that's affecting the outcome of the elections. After examining the evidence, the court agreed with the petitioner, ruling that the level of non-compliance materially affected the outcome of the poll. It subsequently ordered the EC to organize a new parliamentary election in the constituency to determine the rightful winner. Context for this: NDC, prior to this, has 185 parliamentary seats, MPP has 87, and there are 4 independent. So with the declaration of Kpandai as being vacant, that reduces MPP to 86. If NDC wins this by-election, they will go to 186. That means they have 100 parliamentary seats more than MPP and 4 independent. First and foremost, before even the law, how concerning is it for you in terms of the skew of the parliament we have? Because the previous parliament had 137. Now we have 185 and 87. Almost 100. Indeed, the 4 independents say they are with the majority. So there's a hard 2/3 in a competitive election. This is unprecedented because in the 93, it wasn't a competitive, there was no opposition. So again, even before we get into the law, this is very serious for our democracy. How do you interpret that?
It's a very interesting situation. I will put it interesting situation. But if you remember the Labour Party in Britain, before New Labour was brought about by Tony Blair and others, the party was really in a dissipated mood. And the majority of the Conservatives was such that you would think they would never come back. But that is the nature of politics. I believe that the totality of events prior to that election put the MPP in a very, very difficult situation. And I will leave it at that. What really interests me, because as for the large majority, it's already a fait accompli. So there's nothing much one can do about it at this time. But I don't really look at it so much in terms of the fact that numbers are required desperately. No. But what is the principle of what is happening? The suit was such that a plaintiff went to court seeking a certain remedy with regard to certain specific areas where they said there was some malpractice or whatever it was, misdoing. Mm-hmm. Then they had judgment not only for the rerunning of those few polling stations, but for the election as a whole. It is very, very difficult to imagine by what kind of application of law this decision was arrived at. Because the people went looking for a goat, they came back with a cow by way of what was presented to them by that legal pronouncement. Therefore, they are aggrieved, and they have not even gone on to the Supreme Court to have that whole document by way of the judgment quashed. They have also appealed, and they have filed a stay of execution pending the appeal. I can assure you, in all my legal practice, I never heard of a situation whereby, notwithstanding the pendency of a stay of execution application, a person is nevertheless allowed to go into execution. In fact, we have had certain developments in the law in Ghana. There was a time when an appeal stayed automatically as to prevent execution. And when you filed an appeal, it will automatically prevent the other party from going to execution. Then we saw that that thing was being abused. Some people just filed an appeal by way of what I may call an injunction, in the sense that it will restrain you from going any further. But they won't even prosecute the appeal because they don't believe in the appeal. Therefore, the rules were changed. It says you may not only file an appeal, but you may also file an application for stay of execution. When a matter is so before a court of competent jurisdiction, it is contempt of that court. It's an illegal act if you should proceed beyond further to make a nullity of the obvious ruling that will come. I want to read something here for you. In a case in which a number of before the Supreme Court over this same matter, the majority central argument that is filed by the majority leader in Parliament is that CI 132 amended Rule 27 of CI 19 in such a manner that the mere filing an application for stay of execution no longer operates as a stay, and that execution may therefore proceed. With respect, I am not persuaded at all. Because if you look at what the law has done for us all, in any case, Justice Bafo himself, Chief Justice of the Republic now, in the well-known case which he himself also gave this ruling, I want to read a bit of it for you. It is a natural sequence in civil trials that once a person feels aggrieved by any of a trial court, be it interlocutory or final, he has the right to appeal to a higher body by filing a notice of appeal. It is provided by all the rules of court, namely High Court Civil Procedure Rules 2004 CI 47, the Court of Appeals Rules 1997 CI 19, and the Supreme Court Rules 1996 CI 16, that an appeal in itself does not operate as a stay of execution. That is so. However, he goes on, the same rules provide that when an application for stay of execution is pending for hearing, it stops execution until the same is heard and dismissed. The relevant provisions in CI 19 Rule 27.2 reads, where an application for stay of execution is pending for determination under sub Rule 1, the proceedings for execution of the judgment or decision to which the application relates shall be stayed.
So this is the current CJ's.
Exactly, shall be stayed. I've read him. Seriatim. Assuming two people are contesting a court case over a building. The plaintiff has won at the High Court. The defendant appeals to the Court of Appeal. Before the appeal is heard, and also whilst an application for stay of execution before that court is heard, the person who had a judgment now moves over there and then sells the house, and then take the money away because he has been allowed. What do you think will happen? That means he has forestalled, he has undermined the legal process that would have done justice. At the moment, they have put even the Electoral Commission into a very difficult situation, in that the Electoral Commission, if the commission, the chairman or whoever goes ahead and breaks this law, that person can be jailed for contempt.
But they are just following Parliament, because Parliament declared the seat vacant. So that was automatically triggered by the actions of Parliament. So the original sin, if your point is to be taken, would have been committed by the legislature.
Well, but that is also another issue. The legislature, but actually what I read or I heard what the speaker said earlier, I don't know where this letter is coming from, honestly.
Because he initially gave a 1 week.
No, you see, the 1 week stay is automatic by law. And that also has got a reason, is that also?
Yeah.
It is to allow you to do whatever you want to do by way of an appeal or whatever. Because if we leave the courtroom and then immediately they go and execute it, bailiffs are following, and then go and execute it, then how will an appeal be meaningful? That appeal will be rendered odious because it will have no effect. In fact, if so, then the provision in this constitution giving the Ghanaian a right of appeal will be null and void. Because anytime you win a case, all you have to do now is to say, well, I've won the case.
So if I hear you right, the original problem is Parliament's declaration of the vacant seat when there was clearly an appeal pending.
Yes. And that is why you realize that in the cases of Rebecca Adote, Honorable Abu Dhabi, Honorable Sankara, Honorable Jesse Kweisin, and this particular one, in all those cases, there was a stay of execution.
Fair enough.
And in fact, experience of some, in the Jesse Kweisin's case, there were so many applications. On one occasion, Jesse Kweisin had lost an application before one of the courts. And then immediately there was an attempt to say that execution must therefore be entered into and for him to be chopped out of Parliament. I said, no, it is within my knowledge that he has got some application before the Supreme Court, and I'm not prepared to go and stand in the Supreme Court for contempt. You see, because the moment you forestall a court which is going to hear a case, just because you have won the case below and you are aware that he has filed an application for stay, stay means stay.
Fair enough. I just wanted to point out, without equalizing, that some people point to what happened with the Auditor General Daniel Damolevu. Somebody had challenged his nationality and he had been asked to retire. There was a Supreme Court matter that had not been determined. The then president removed him and replaced him. So if we are saying that court processes must be obeyed, in that instance you can say the executive rendered the final vindication of Domelevo odious, because he also, it was determined by the Supreme Court that his removal was illegal. By the time he had been replaced, and when the matter was finally dispensed with, he had already passed retirement age. So people point to these precedents by way of some sort of political equalization.
I don't know whether there was a stay of execution application before the Supreme Court. I don't know. So I will not be able to comment on that matter. But definitely, if there was a stay of execution application during the pendency of that case in a court of competent jurisdiction, it will be illegal to proceed in a way that will undermine the ultimate decision that the court might come to. Just like what I've just told you, assuming the person now runs away with the house, sells it the following day, and leaves the jurisdiction or whatever, when the person wins the case, what are you going to tell him? In other words, you must always give room. And if this kind of equalization tool comes in, then analysts and commentators must condemn both.
So by way of legal pathway, should the MPP sue Parliament for not respecting the stay and the pendency of the Supreme Court judgment, or take part in the election? Because the date has been set by the EC. So what should an aggrieved person do in this case?
Well, I don't know what really has happened as of today, but the person aggrieved, the aggrieved person can ask that anybody who was involved in this must be dealt with. And also they can take it for certiorari to quash that declaration by the Electoral Commission. And I'm told that elections really cost so much money. So one must be very, very careful. Otherwise, the Electoral Commission people might be guilty of financial loss.
But why the EC and not Parliament? Because the original challenge, the EC was just following what Parliament declared. Because the Parliament declared the seat vacant, after which the EC moved into. So it was not the EC that interpreted the law. It was Parliament through the Speaker, and that letter that was read, that led to that position.
If it were me as an electoral commissioner, I would look at whether there's a case pending before a court of competent jurisdiction.
Irrespective of what the Speaker has declared.
Because he cannot exonerate you.
But why? Aren't you supposed to say
Because when
Parliament?
you go to court for contempt, they say, are you aware that there is this case before me or before us in this court? The answer is your answer. And if you are aware, you must not do anything to render an adjudication of that court of competent jurisdiction be of no effect.
Well,
make it otiose.
Once the seat has been declared vacant, the EC has no choice.
No, I don't think so. I don't think he has no choice. Because you see, that declaration may not be legal.
So let somebody challenge that declaration.
Well,
that's not the EC's job. Because the EC...
I've told you what I would do if I were EC. If I were EC.
But are we not having a clash between the legislature and the judiciary all over again? Which seem to, again, have become a major issue in the previous Parliament.
I think...
It seems to be that the Parliament and the court have had this tango that we are not resolving. And it's not this... Even the 8th Parliament had that. Not even this 9th one.
And it must... If there's any such problem, it must stop. Because now I have no doubt in my mind that the only pathway to justice, the administration of the law, you cannot have a judgment and then during the pendency of an appeal and an application which may go either way, you take any step that will render nugatory the ultimate
decision. Let me make it
report.
more interesting for you. You quoted the CJ, and I have nothing against the CJ. But even he can be said to have been a beneficiary of this breach, because the former CJ has cases pending in relation to her removal. Oh, those processes have not been exhausted.
I don't think...
I
don't think I want to go...
No, I'm saying that if you just read his own... I'm not asking you to comment on his personal...
No, okay, fine.
What I'm saying is that...
Then it's your comment.
No, I'm providing that to enrich the discussion, that the former CJ had not exhausted all her appeals, and yet her removal process was consummated by his appointment. And the judiciary, as constituted now, is headed by a man who benefited from the same thing. Is that not?
What I know is that the law is very clear. It is the law in any civilized society. Otherwise, we should remove the right of appeal from our constitution. Otherwise, there's no appeal anymore. In fact, if nothing happens in this matter, the constitution which provides for the right of appeal will itself become nugatory.
Do you think MPP should take part in a by-election on the basis of all
that one is, well, I don't know whether it's a political or a legal question, but I'm interested in the legal arena.
But shouldn't the political question derive from the legality? Because that's a party of lawyers. So obviously the political decision to contest should be based on some legal grounding.
Because if the act is now what you regard as an illegality, then you may as well concentrate on declaring it as a nullity. But because this can be very, very embarrassing, you know. You may elect one member of parliament, you will go there only for the court to say, no, you have no business being here, get out of here, and then for the other person to be restored.
But if the original candidate takes part, has he not endorsed the so-called illegality?
No, well,
because if Mr. Nyindam decides to contest in this election,
the law,
which we are told he has expressed interest in contesting.
In the law, we say you are doing something entirely without prejudice.
Meaning what?
Meaning you don't accept the situation, but out of the abundance of caution, you still want to participate.
Without prejudice?
Yes, without prejudice.
We'll take a break without prejudice and come up with our final talking point. Stay with us.